The next session is a big favorite of this conference, and it's going to address the trends that we're seeing in the mergers and acquisitions space and discuss the current state of the M&A market. As a first-year associate, I thought M&A meant happy law because people would be making money together and then everybody would be happy that I was around. I'm not an M&A lawyer. I learned that's not all of what M&A is about. But these folks are the experts, and we are led by Sharon Flanagan, who is the San Francisco office managing partner of Sidley Austin and a leader of the firm's global life sciences practice. Sharon advises a number of public companies on corporate governance, disclosure, other SEC compliance matters, as well as proxy advisory firm matters, shareholder proposals, corporate governance, best practices, and M&A, and she's going to guide us through this session. So thank you, and thank you, Sharon.
All right, thank you, Dixie. Well, we're excited to get some M&A time at this conference, and our goal today is to really bring you current on everything that's happened in the last year in Delaware that's relevant to an M&A practice. I have a great panel today with me. I have Rick Kleinman, who is a partner at Hogan Lovells Silicon Valley office. Rick has chaired this panel for many years, and we are very grateful for his many years of service in that role. Next, we have Saeed Muzumdar. She is a partner at Gibson Dunn in their New York office and co-chair of their M&A practice. Then we have Rita O'Neill, a partner at Sullivan & Cromwell's LA office, where she serves as the co-head of the firm's global private equity group and is also the vice chair of the ABA M&A committee. And finally, David Katz, who's a partner at Wachtell in New York and focuses on M&A, corporate governance, and shareholder activism. All right, so before we get started on the substance, I wanted to just give you a little bit of context for the market. What have we seen in the last year? Well, it's certainly been an interesting time for M&A in the last few years. When the pandemic started, we had that very momentary pause in activity, and then things came roaring back and basically did not stop until maybe the second quarter of last year. But then they did stop. So what we see here is when you look at worldwide M&A activity by deal value, there was a 37% drop last year compared to the prior year. That is the largest ever percentage decline since 2001. That was the year some of you may remember when we had the dot-com bust and, of course, 9/11. So this was a greater drop even than the Great Recession years, so pretty remarkable. Some of this, I think, relates to the SPAC meltdown. So, remember, SPACs, they're not really M&A transactions. It's really a vehicle for going public, but they were in the deal volume, so there's a little bit of that, I think, in there. If we look at cross-border transactions, it's even more stark. Cross-border M&A fell 46% last year compared to the prior year. And no doubt that's the influence of geopolitical events in Ukraine, Russia, and China. So it's an interesting time. We'll see what 23 brings. But meanwhile, let's get back to the practical side of things. We're going to start at the beginning with LOIs and term sheets. And what we'd like to talk about is, when is a letter of intent that we call non-binding, maybe a little more binding than we intend? And for that, I'll turn it over to Saeed.
Thanks, Sharon. So our favorite, of course, is when our CEO calls us and tells us, I have a deal. I wrote down on a napkin with the CEO of my counterparty, $3.6 billion, 80-20. We both signed it. We're good, right? And I'm like, oh, Lord, if we ever get sued, we just sold this company. So hypothetical situation, of course. When are LOIs actually binding? Generally, I would say we think of LOIs in three categories. The absolutely non-binding agreement to agree, and then Delaware has sort of told us that there are two binding LOIs, the so-called Type 1 and Type 2. In 2022, this was tested in Cox versus T-Mobile, which we'll talk about in just a second. But first, let's go back to SIGA, which was a case from 2013 and again in 2015, where the Delaware court sort of laid out for us what are the Type 1 and the Type 2 LOIs. In the context of Type 1, that view is it's fully binding. All the terms are laid out in this agreement. You may not have a definitive document, it's not a contract, but you've listed all the material terms of the agreement, and therefore you have a deal, even if you do not further document it through a contract. Type 2, on the other hand, is a situation where you have some, but not all of the material terms laid out, and the rest are meant to be negotiated in the context of definitive documents. So in this circumstance, which was the case in SIGA and also in Cox, the so-called Type 2 agreement, what are the obligations of the parties in that context? Essentially, what Delaware has told us is you have a good faith obligation to negotiate. So then what happens if you breach that good faith obligation to negotiate? In SIGA, it ended up being a bit of a damages case. In Cox, what happened was Cox and T-Mobile had entered into settlement agreements pursuant to which they had essentially laid out terms by which Cox would enter into the mobile wireless space, and they basically said we would have a 36-month exclusive agreement, and T-Mobile would be the provider for Cox to enter into this space. So this happened a few years back through a settlement agreement. The parties negotiated, went back and forth. T-Mobile, as we know, was acquired by Sprint. So Sprint at that time was doing its work. They laid out different options for a type of agreement, whether Cox would be interested in or not. They ultimately weren't able to agree, and Cox went out to Verizon to seek an alternative transaction provider and ultimately agreed with Verizon to enter into a deal with them. So, of course, T-Mobile sued, saying you have no right to enter into the market. In fact, our agreement from the settlement was a binding agreement that you have now breached, and they sought declaratory judgment. The court basically went back to the SIGA framework and really didn't change anything between Type 1 and Type 2. They concluded this was not a Type 1 agreement. All the material terms were not laid out in the context of that settlement agreement, but it was a Type 2 agreement, and there was an obligation to negotiate in good faith. What the trial court decided in Cox was that the parties had negotiated in good faith, weren't able to enter an agreement, but because of the wording of the LOI, which I think we have on the next slide, Sharon, it essentially, Cox was blocked from entering into a transaction with any other party, so essentially invalidating the deal with Verizon. And what the Delaware Supreme Court said was that's not correct. That doesn't work. It's not that the LOI was a pseudo-exclusivity provision that would prevent the counterparty from doing a deal with someone else. Instead, it was just that the parties had to go back and negotiate in good faith. If they couldn't enter into a deal, they couldn't enter into a deal. This case is still ongoing at this point in time.
So was it surprising to you that the court, going back to SIGA, the court said, basically, if you've got a term sheet that you fully negotiated and you're getting ready to put it into a definitive agreement, that if you try to reopen one of the provisions that was agreed on, that's an unambiguous act of bad faith?
It's interesting, right? Because it's hard when you look at all these cases to separate the facts from what actually occurred. In the SIGA example, which I do think is extremely interesting, originally, SIGA was looking for a counterparty in this transaction because they were failing. They had a drug. They weren't sure if it was going to get further. They needed additional funding to bring it to market. And so what they entered into was essentially like a rescue financing, a rescue merger with the counterparty, where the counterparty was agreeing to give them bridge loan. They were agreeing to acquire them. And then they put in place sort of a consolation prize termination fee, where they essentially said, if we can't enter into a merger agreement with you, we still get a license. So they still got a license to the product. From the time that SIGA went out looking for its rescue financing to the time that they started negotiating the merger agreement and the license agreement, SIGA's prospects changed tremendously. And all of a sudden, the company went from being on the brink of a bankruptcy to having a valuation in the multi-billions. And they were like, whoa, we don't want to sell so cheap. They didn't want to do the merger agreement, and they didn't want to enter into the license. So while they went back and forth in the context of some of this negotiation, whether that was in bad faith, my suspicion is some of the facts that came out in the context of the trial weren't all that great for them, and when you have those sort of smoking gun emails, it's going to hurt you. What's super interesting about SIGA 2 is a damages point, which I think we also have on the next slide, that sort of goes through what are the damages that the counterparty is entitled to if you end up not entering into an agreement. And so in this context, in the SIGA case, the Chancery Court said that the counterparty was entitled to reliance damages, essentially, that it was that they were estopped, and so they came up with a number, and the Supreme Court instead said that the counterparty was entitled to expectation damages as if the parties would have entered into an agreement but failed to do so, and they concluded that they were entitled to $115 million worth of damages as if they had entered into the license that never was consummated. So note there a little bit of a difference between what we've seen in other courts, including in New York, and frankly, I think practitioners probably anticipated Delaware would have thought expectation damages was too speculative and too difficult to calculate in this context, but here we are.
So now that you've scared us, if we include a disclaimer like this that basically says, hey, I don't care if it's type 2, we have no duty to negotiate in good faith, are we good?
Yes, the answer is yes. I mean, I think it's hard for us to think of us as M&A lawyers ever sending out the LOI that doesn't include the language that says you can essentially walk away from the transaction at any time for any reason, and we'd strongly recommend that. You know, you always get those process letters where they're like, okay, your first round bid is your non-binding LOI and your second round bid is your binding LOI. You're like, no, there's no binding LOI. Don't change the language. We're saying that the parties it's all subject to the negotiation of definitive documentation. There's no obligation to continue to negotiate, no obligation to negotiate in good faith, frankly, if we want it to be an agreement to agree.
Yeah, so the practice pointer here is this language we've highlighted, and in particular B, expressly disclaiming the duty to negotiate in good faith. All right, so let's turn next to M&A carve-outs. We're going to do another kind of more practice-focused segment. And we all know what the MAE carve-outs are all about, but you know, sometimes things that we assume are just sort of standard fare and we always accept them. I think maybe Rick's going to argue we shouldn't be accepting them. So let's take a look. Rick?
Yeah, and thank you, Sharon. And let me say at the outset that this is a topic of very, very broad importance because it's relevant both to acquisitions of public companies and also in acquisitions of privately held companies. And I know many of you in the audience deal more often with privately held companies than public companies. So I'm going to start with some historical perspective. For M&A practitioners, the phrase material adverse effect, MAE, has been in the spotlight now for at least 2 decades, going back to then Vice Chancellor Strine's opinion in IBP Tyson, 2001. And the former Chief Justice, Leo Strine, is sitting here in the audience somewhere, and we're going to take his name in vain in a few cases. The reason the MAE concept is so important is that in acquisitions, at least of public companies, and increasingly in acquisitions of privately held companies, an MAE is, as a practical matter, the only viable way out of the deal. Putting regulatory issues to the side, ignoring covenant breaches, which we're going to be talking about in a little while, and also ignoring outright fraud. The only way to get out of an announced acquisition of a public company, at least, is to establish either that an MAE occurred or that the target company's reps and warranties are wrong to the level of an MAE. So MAE is obviously a critical concept. Now, Vice Chancellor Strine in IBP Tyson, as many of you know, established an extremely high bar for proving an MAE. A buyer claiming an MAE must show an extreme negative impact of durational significance on the target company's long-term earnings potential, which is a remarkably difficult standard to satisfy, a remarkably difficult thing for a buyer to prove. Not impossible to prove, because that standard was actually satisfied, as many of you know, in the Acorn decision back in 2018, where a buyer was able to prove an MAE, albeit on facts that, I was just discussing this with the former Chief Justice before we got on the panel, outrageous facts. But it's not impossible to have an MAE using the IBP Tyson standard, but still, it's an exceedingly difficult standard to meet. And some practitioners, including practitioners on this panel, would probably refer to it as almost impossible to satisfy. But what's important to recognize is that it has now become even more difficult for buyers to walk away from their M&A deals. And that's because of a trend that began right around the time of IB Tyson and that has accelerated greatly since then. And that trend is carve-outs, the carve-outs that Sharon alluded to in her introduction. These are express contractual exclusions from the definition of MAE. And with MAE carve-outs in place, a buyer who successfully shows that they have basically satisfied the Strine standard in IBP Tyson can still be forced to close if the target company can show that the MAE arose from one of the excluded factors in the MAE exclusions. So as hard as it is for a buyer to walk away from a deal under the IBP Tyson standard, it has now gotten that much harder to do these given the omnipresent carve-outs. And these carve-outs, believe me, are omnipresent. They are truly ubiquitous today. The version of the MAE clause in IBP Tyson, a lot of people don't remember this, contained no carve-outs, and that was actually fairly typical for agreements of the time back in 2001. But since that time, MAE carve-outs have proliferated in both public and private company deals. They've proliferated so much that, according to these ABA deal point studies that we all consult, there are carve-outs of some sort in fully 100% of the surveyed deals. And as our slide shows, today a majority of deals contain over a dozen carve-outs. Think about that. So in practice, things have gotten to the point where MAE carve-outs have become absolutely standard. Buyers' lawyers don't fight about them anymore. And in practice, these carve-outs are carried forward, and you've all done this, from deal to deal to deal to deal, practically verbatim, and often, I would say, without much thought. And that, I would submit to you, is a mistake. These carve-outs can be decisive. They can be outcome determinative. Look at the Genesco case cited on the slide as an example of that. Former Chief Justice Strine also reminds me that there were plenty of examples of this during the financial crisis, where there was a clear MAE, but it was the carve-outs that ended up allowing the buyer to work and escape. So it behooves practitioners to scrutinize the wording of these potentially dispositive MAE carve-outs very, very closely. And as practice pointers, because that's our goal on this panel, is to provide you with useful practice pointers, I'm going to quickly zero in on two common MAE carve-outs that I think are, as Sharon suggested, not necessarily being negotiated properly in practice today. The first carve-out, which I think is being poorly negotiated, in this case by buyers, is the carve-out for actions required to be taken by the target company under the acquisition agreement. So if an action is required under the acquisition agreement, it's not an MAE. And this appears in a vast majority, over 90% of the deals surveyed. And while it may sound appropriate for a buyer to be prevented from terminating the deal based on something that the target company was contractually required to do, in my mind, it's not really an appropriate carve-out. Why? Because the target company is subject to many generic affirmative covenants in the acquisition agreement that include a requirement to operate the business in the ordinary course between signing and closing. But with the benefit of hindsight, it is all too easy for the target company to attribute practically any post-closing setback to its normal course operation of its business. So, as a general matter, buyers are best advised to simply delete this carve-out or at least narrow it considerably. I mean, I always get rid of this carve-out when I'm on the buy side. I think you should too, but many people are not doing it. The second carve-out that I'd like to highlight is also a common one, and this one also appears in 90% of deals, and it relates to natural disasters, maybe something we should be more attuned to in days of climate change. Floods, hurricanes, earthquakes, and the like. But this is one where I think the sellers and the target companies, not the buyers, are getting it wrong. And that's because of a buyer favorable clause, the so-called disproportionate effects clause that is typically included in MAE definitions. You've all seen it. This is the clause that says, to the extent a particular MAE carve-out has a disproportionately bad effect on the target company compared with its competitors in the same industry sector, the carve-out is simply disregarded. It is nullified. It's one of the few buyer-favorable provisions included in modern MAE definitions. And the question that comes up in MAE negotiations is this. Well, which of the many MAE carve-outs should this disproportionate effects clause apply to? Now, there are some MAE carve-outs to which the disproportionate effects clause should pretty clearly apply, such as the carve-out for adverse effects caused by general economic conditions. If a recession triggers a 70% decline in the target company's revenues, but only a disproportionately low 10% decline in the revenues of all of its competitors, then it's logical to argue that the target company has suffered an MAE and the buyer should be able to walk away because the target company was disproportionately affected by the recession. But what about the natural disasters carve-out? Here, I think the risk calculation is often different. And as a business matter, many sellers believe that the risk of a natural disaster or some other act of God should fall firmly on the buyer. And it's a matter of business risk allocation. There's no right or wrong answer here, but that's the way many parties come out. And so in other words, if a decline in the target company's performance can be attributed to a natural disaster which was outside the party's control, then the buyer should not be able to walk away because of that. But think about what happens if the target company agrees that the disproportionate effects clause should apply to the natural disasters carve-out. So a target company whose operations are in Florida and has its operations completely wiped out by one of those famous Florida hurricanes will always be disproportionately affected compared to its competitors who have operations in distant locales that aren't affected or even touched by the hurricane. So the buyer, in effect, will never be able to invoke that hurricane carve-out, and why bother to include it at all if there is a disproportionate overlay on it? And I know what you're thinking. You're thinking that, well, on the sell side, most well-advised sellers do not allow the disproportionate effects carve-out to apply to the natural disasters carve-out. But you'd be wrong about that. The ABA studies that I alluded to earlier show that in a vast majority of the agreements, the disproportionate effects carve-out does apply to the natural disasters carve-out. Go figure, I was surprised too, but the message for sellers is, of course, be smarter about this one, push back on this point. On the buy side, I always push to have the disproportionate effects clause apply to the natural disasters carve-out. I'm frankly amazed at how little pushback I typically get because it's, quote, standard practice to do that. So Sharon, those are our practice pointers on MAE carve-outs. As usual, they come under the category, the words matter, and practitioners should be accordingly very thoughtful and not robotic, as some of them are, about the way they negotiate these carve-outs.
All right. Well, Rick, thank you for painting a pretty bleak picture of MAEs as being nearly impossible, and I do agree with that. And I think it's because of that, because of the impossibility of proving an MAE under the Delaware standard, what we've been seeing is a number of cases where a buyer trying to walk from a deal will position the right to terminate on two theories. One, MAE, knowing that's going to be pretty difficult, and the second on breach of the covenants between signing and closing, and in particular, the breach of the covenant to operate in the ordinary course of business. So between signing and closing, the seller is supposed to basically continue to operate the business in the ordinary course. And that makes sense because the buyer has decided it wants to buy the business because it looks a certain way and doesn't want that to change. So it's like if you were to buy a house and while you were under escrow, they tore down the garage and painted the house purple. You're not going to be that happy about that. That's not ordinary course. But you'd expect they'd continue to mow the lawn and take care of the general upkeep of the house. So what we've seen is cases that are starting to focus on this second prong. And Rick, you mentioned Acorn. Acorn, got a lot of attention when it came out a few years ago because, of course, it found the first MAE in Delaware, which was really, a landmark case. But there was actually a sleeper issue in Acorn, and that sleeper issue was that the court also found that the buyer had an independent right to terminate, even if there had been no MAE, because the target breached the operating covenants between signing and closing. Now, as Rick said, Acorn was pretty egregious. I mean, there was, fraud going on between signing and closing. So you may remember with Acorn, it was a life sciences company. They had all kinds of issues relating to their clinical trial data and were submitting data that was inaccurate to the FDA. But what was Acorn doing between signing and closing? Well, they told their IT team to stop doing any data integrity projects. They told their quality team to only look at historical audit results and work on those historical audit results. Don't look at we don't want to do any new audits. And then finally, when the whistleblower letter came in about all these issues at the FDA, they decided not to investigate. So that's pretty egregious. I think we could all agree. So what did that covenant say that Acorn was supposed to do between signing and closing? Well, it didn't require perfect compliance. It didn't require that everything had to be exactly as it had been before signing. It was in all material respects. So there was a little bit of wiggle room. And you may be surprised that the standard for judging, what does it mean in all material respects? The standard for that, at least as Fresenius, the buyer, argued and the court agreed, was a 10b-5 standard. So here we've got a securities thing coming back in our M&A panel. The standard being, would a reasonable investor consider that it altered the total mix of information? So that was the standard. And the court said, we're going to look at two things. We're going to look at what would a typical pharma company do. And they said, Acorn clearly fell short of that standard. And then they also looked at whether Acorn's conduct deviated from a buyer's reasonable expectation about what they would do between signing and closing. And they did. And so Fresenius could have walked even if the MAE had not been found. So let's flash forward to a more recent case where we had a similar situation of arguments in the alternative about an ability to walk. So this is the Twitter case. So remember that Elon Musk made an unsolicited bid to acquire Twitter. He did not conduct any due diligence, interestingly, just kind of went ahead with that offer. And then once the deal was signed, Musk and his team started making all kinds of requests for information. They were asking for the fake accounts, the so-called fire hose of information, and all purportedly under the access covenant, which gives buyers the right to have reasonable access between signing and closing. So they're making these demands, and Twitter was trying to comply and actually was providing a lot of information, but seemed to never be quite enough. So in July, Musk delivers a termination letter claiming both that Twitter is likely to suffer an MAE because of these fake accounts, and that Twitter had breached its pre-closing covenants by refusing to give the data and by breaching the ordinary course covenant because they had fired a handful of people and instituted a hiring freeze. Then the subsequent termination letters kind of ramped things up a little bit and declared there was in fact an MAE, so not just a prospective, but an actual MAE had occurred because of a whistleblower complaint. So again, whistleblower complaints between signing and closing, not usually a good thing for a seller. And also, Twitter paid this leaving executive severance, and they said, well, that was also another breach of the ordinary course covenant. So we know the MAE argument was going to be an uphill battle. That's kind of pretty clear. Well, what about the covenants? Well, once again, there was an all material respects qualifier, pretty standard in the covenant and in the bring down condition. So would Musk have met that 10b-5 standard that a reasonable investor would have felt that it had altered the total mix of information? I'm pretty skeptical of that, and in fact, we'll never know because the court never had to rule on it because the deal, as we know, closed. Now, it may be that Musk is wishing he had continued that litigation now that Twitter has been a difficult road for them ahead. But I think the takeaway here is it's a cautionary tale to sellers, which is between signing and closing, you want to be meticulous about your compliance with covenants, and you want to be very careful that your client is complying. So another area where these covenants have come into play have been in the COVID cases, and Rita's going to talk about those. We've got this obligation to run the business in the ordinary course, but we've got this major unprecedented pandemic. How is that even possible for a seller? Rita?
Well, definitely meticulous compliance with covenants is a challenge when you're facing a global pandemic. In the US and Delaware, we have 3 cases to look to for guidance on whether actions taken by a target in response to COVID breach the interim operating covenant. There's AB Stable, which we have up on the screen, which dealt with the closing of hotels. We had Snow Phipps, which dealt with cost-cutting measures in connection with a cake and cupcake decorating business, and then level 4 yoga, which dealt with the closing of yoga studios. In only one of the cases did the court find, that was AB Stable, that the target had breached its obligation to operate in the ordinary course, consistent with past practice. And all three of the cases, though, interpreted the language, how to operate in the ordinary course of business, consistent with past practice, in somewhat similar ways. The first is ordinary course of business means how does the company operate during normal times? It isn't in extraordinary times, it isn't in light of the pandemic, but it's in normal times. The second piece is consistent with past practice, means the only relevant issue is whether that target's own post-signing operations change materially from its pre-signing operations. The second part is we look at the conduct of the parties and what they did between signing and closing. One of the key things in every interim operating covenant is it says you have to operate in the ordinary course, consistent with past practice, unless buyer otherwise consents. And so one of the interesting things that Vice Chancellor Laster had focused on in AB Stable is that the seller could have sought buyer's consent and did not. And as is quite typical in those provisions, it also provides that buyer cannot unreasonably withhold that consent. So thinking about operations going forward and how do you interpret these covenants, we'll come back to this in a minute because that's, what do you do when you have a potential unexpected event that occurs between signing and closing, and how do you address that? One key thing to help sort of figure out how this may go going forward is two Canadian cases, interestingly. Although they followed the US cases and the Delaware cases in finding and interpreting the MAE provision, and both of those found that there was no MAE, interestingly, they looked to the MAE clause and the carve-outs, particularly the ones that Rick had outlined for you, and including the fact that they carved out illness in interpreting the interim operating covenant. And in looking at the interim operating covenant, the court said, we need to look back to the MAE clause. The parties had allocated systemic risks and put those risks on the buyer. And so it would be inappropriate and unreasonable or inconsistent with the MAE clause to then allow the parties to use the interim operating covenant to then say, okay, well, we allocated to buyer systemic risks, but we didn't allow seller to react to systemic risks such as COVID when they arise. So it'll be interesting to see how that plays out with future US cases, but I do note that in both in Snow Phipps, the court found that the reaction that Snow Phipps had taken to the pandemic was de minimis first, it wasn't material, and then also is consistent with how the target had reacted to economic downturns in the past. And then in level 4 yoga did consider the contractual arrangements between the buyer and seller in how the seller had acted, the target had acted. So now we go to the future of what do we do with this language. As many of you saw during COVID, when agreements were being signed, we added a carve-out regarding COVID measures and saying you have to operate in the ordinary course, consistent with past practice, except for actions required by legal requirements or COVID measures. So one query whether or not we need this now. We're in 2023. We've been dealing with COVID since 2020. Do we have enough past practice to establish how a target should actually react to COVID? But what about where do we go from here with the next extraordinary event? We don't want to people don't want to get stuck in this place. And so there, query whether or not it makes sense for the seller to seek consent of the buyer. Because when the seller does that, if the buyer says no, and the buyer can't unreasonably withhold its consent, then what you're doing is you're now saying buyer is the one that breached the merger agreement. And so it'll be interesting to see where we go from here, because this won't be the last unexpected event. So ask the buyer. Ask the buyer if you can do it, although many in this room have told me they disagree with that approach.
So ask for permission, not for forgiveness, is what we're hearing. Okay, got it. All right, so let's turn to a couple issues in public M&A. First, the entire fairness standard. We've got another Elon Musk case, because we just can't get enough. This time involving Tesla and whether a conflicted transaction met Delaware's high standard of entire fairness. So David, tell us about Tesla.
Tesla sort of turned some of what we learned in law school and as young lawyers on its head. Everybody read Weinberger v. UOP that dealt with conflict transactions. And the outcome of that case said there are two essential elements. You need fair dealing and you need fair price. I don't think anybody can argue in the Tesla situation that there was a fair process or fair dealing. And the court goes out of its way to address a number of the points in that case, in that situation, where there was not, quote unquote, fair process, fair dealing. No special committee, while there was majority and minority vote, the board as a whole negotiated. You had people who were not deemed as independent because they had interests in the target participated in the negotiations. And the court looks at all that and says, at the end of the day, we're going to focus on fair price. And although using the court's own words, the process was, quote unquote, far from perfect, at the end of the day, Tesla ultimately paid a fair price, and a patently fair price ultimately carries the day. And so what that is saying is that, you can try, if you're in entire fairness, you could focus only on the fair price provision and prong of that case. I still think that that's wrong. I think that at the end of the day, anybody that tries to focus only on price and rejects process is likely to get burned by that you should be focusing on both a good process as well as getting a fair price. To some extent, the process may influence whether the price is considered to be fair or not, especially to the extent that you can replicate arm's length negotiations between the parties. But it would be a mistake for people to simply say, after this case, Weinberger v. UOP doesn't mean anything anymore because fair dealing is out the window. I just need to focus on fair price. And I think that, while it is what the court said was okay, is not a way to try to negotiate these types of transactions. And more often than not, I think we'll end up with the conflicted party having a problem at the end of the day.
All right. So we're starting to hear about contingent value rights again, CVRs. There were 3 deals during J.P. Morgan just during that week with CVRs. What is going on, David, with CVRs? Is this like the locusts? They just come back every 17 years? What's going on? Tell us.
CVRs are an interesting animal because what they are used to do is to try to bridge a gap where there's a disagreement in the parties on value. And most of the time, it's focused on an event or a process or a litigation or something like that, where one party thinks it's very valuable and the other party is not willing to pay any value for that. And so you see these CVRs in mostly biotech and healthcare company cases, although we've seen them in some other situations as well. And I think that in the down market that we're experiencing today, you are much more likely to see parties try to use this type of mechanism to bridge value gaps. And where there's an ambiguity there, you really need to make sure that these CVRs are properly drafted. That can often be a problem. And it's very simple if you do it the right way to say, look, if X happens, then people get paid Y. And if X doesn't happen, people don't get paid Y. Now, there are many more complicated mechanisms here. It may be if X happens, people get paid Y. If X minus 1 happens, people get paid Y minus 2. There are all sorts of gradations that you can do. The more complicated, though, you make these instruments, the less likely you're going to be able to persuade people at the end of the day that they should agree to them. And we've seen, especially in boardrooms, when you're trying to explain these contingent value rights, people getting very nervous that there is a lack of clarity. The other thing that has happened is in the terms of these CVR provisions, they're pretty straightforward in what the requirements are, what the trigger is, but where there's been litigation about these is where somebody argues that the buyer didn't try hard enough or take whatever actions were necessary for the result to happen as part of the case. And so whether, for example, in a litigation, you might say, well, you can't settle this out because settling means that you'd be undoing the idea of behind the CVR, but maybe you don't litigate as hard as you want to, or you don't spend millions of dollars on litigation to get the result you want. So there are cases and situations involving CVRs where, as a matter of course, these transactions have come under fire and been used to have some pretty interesting arguments in front of either the Chancery Court or other courts about whether or not the terms have been breached. As far as usage is concerned, I did note that we see this mostly in life science and healthcare transactions. The actual number of cases where CVRs are used is only about 2.8% in the last 5 years. I think we will see more of those. But again, it really depends what you're focusing on. If it's something, the reason it lends itself in the healthcare and life sciences, a lot of this focused on the value of a patent or a value of a particular drug product and whether it was going to get FDA approval or what the limitations were going to be. And I think the other way to think about this as CVRs is, especially in private company negotiations, we're seeing these turned into earn-out provisions. So that the buyer is incentivizing the other party to do well so that the company does well and it gets paid on that earn-out. It's another way of thinking about a CVR. I do think that you need to be very careful in structuring these to make sure that they don't be characterized as a security for SEC purposes. I did note that there are real risks here on the execution side, and parties, because there's usually a lot of value involved in a CVR, litigation is often the result where a CVR is not triggered. We have, in some of these situations now, seen people push these to arbitration instead of court cases, and I think that is going to be an interesting development to see how those actually hold up in some of those cases, and we'll see some situations coming down the pike. One of the main issues with them is arbitration decisions aren't published. So if an arbitrator decides that 20% of the CVR should be paid out or tries to split the baby, you're never going to know what the actual rationale behind those decisions are. When there's a court case about a CVR, you can get guidance from that and try and reflect some of that guidance in the structure that you're going to do the next time you use a CVR. The other big risk is, as I said, the risk that this becomes characterized as a security. And on the next page, the next slide, we've got sort of a helpful chart that talks about whether or not it's going to be characterized as a security. The SEC does take the view that CVRs must be non-transferable to avoid being a security. That actually flies in the face in some of these negotiations of what you're trying to achieve, because if it's not transferable, the person who holds the stock at the end of the day and is giving up their stock for this CVR right cannot transfer the value of that. And so it may actually result in some unintended consequences because they may have a different rationale than some of the people that if it was a security and could be traded, they could receive value for it. And that's one of the, frankly, the things that shareholders don't like about CVRs. If they can't transfer the value of that CVR, they can't recognize it. And if they have to wait 2 or 3 years, well, for an institutional investor, that can be an eternity. And it's something that they often don't like. The other pieces of whether or not it's a security are, under the SEC's 5-factor test, is it an integral part of the consideration that's being paid in the merger? Do the holders of the rights have any rights as common stockholders to vote on certain things? Do the rights bear any type of interest over time? Are the rights assignable or transferable? And the SEC really focuses on that. If it's transferable, most of the other provisions don't really matter in their mind. And then are the rights simply a contract right, or is there actually a form of certificate or instrument that sets forth the rights? Again, if it's not transferable, it doesn't really matter as much on that point, but it is something to really think about and focus on. The bottom line is that, there are some other things on the margin that the SEC is focused on, but if you're going to use one of these instruments in a deal negotiation, you want to make sure that you set forth the obligations of the parties very specifically, that there is somebody to enforce those obligations and they have a right to enforce those obligations under the CVR agreement. And you also want to make sure that if you really want to have this litigated and not be subject to arbitration, which may split the baby, you have to make sure that it's not subjected to an arbitration clause, which we're seeing in more and more of these situations. But they are useful, I think, in the down market that we're experiencing. You will continue to see them because there are ways between a seller who doesn't want to attribute value to something and a buyer who sees a lot of value in a specific asset or litigation or claim can try to hold on to that value and get paid for it if, in fact, the seller is correct.
All right, thank you, David. All right, we're next going to do another practice pointer, and we're going to do something about private company acquisitions, so indemnification, which is obviously only relevant in private company acquisitions. We're going to structure this as a mock negotiation, just to give you a flavor of the issues kind of as they unfold. I'm going to play the role of outside counsel to the target company and the selling shareholders, and Rick will play the role of the outside counsel for the buyer. You may want to have your slides in front of you. We'll have them posted here so you can see the language. So Rick has served up a very buyer-favorable draft, I will say, showing some indemnification provisions, and also this is the definition of damages.
Yeah, and Sharon, I've served up here what I consider to be a fairly standard indemnification provision. So what do you want to talk about?
Oh, I'm sure you think it's standard, Rick, but I have a problem here, and that's your very strange fixation with this language, directly or indirectly. It's all over the agreement, but here it really bothers me. You have sellers indemnifying your client for damages directly or indirectly incurred as a direct or indirect result of any inaccuracy of a rep.
Well, what's wrong with that? It's pretty standard verbiage.
Richard, please.
What I see is I see this as a very inappropriate attempt to change the traditional notions of causation, Rick, that have been settled part of our jurisprudence for well over a century. My clients, the seller, shouldn't be liable for some Rube Goldberg type contraption where the breach occurs and then 20 steps later there are damages and somehow my client's on the hook. This has all been established. Remember first-year contracts, Hadley v. Baxendale? It's pretty well-established law.
Well, I vaguely remember first-year contracts, but I do have to say this must be the first time in modern CLE history that we've cited a 19th century case for anything. Now, I suppose I could say that Hadley versus Baxendale and the rule in Hadley versus Baxendale might make sense in a 19th century world of corn mills and mechanical crankshafts, but it really isn't relevant in a high-tech 21st century world. But I won't say that because, out of character, I happen to agree with you. I'm going to accept your deletion of the direct or indirect clause, and out of character, I will observe for all of you that I'm amazed at how many sellers' lawyers don't insist on this change. Get rid of that directly or indirectly if you're on the sell side. It doesn't belong there.
All right, Rick, well, I'm on a roll. For the same reason, I want to limit damages to damages caused by the inaccuracy. So I've taken out this very loose standard you have of in connection with. There's got to be a causal connection, not just some loose connection.
Well, again, at the risk of being a pushover, I agree with you. And again, out of character, I'll observe that I'm amazed at how many sellers' lawyers leave in loose verbiage like in connection with or relating to, instead of insisting on a link of pure causation. So you are on a roll.
All right, sounds good. All right.
So anything else you don't like about my drafting here?
Oh, there's a lot I don't like about your
yeah.
drafting, actually, Rick. So let me keep going. So here we've got the provision on the indemnity. Clause A looks totally fine to me. We're going to indemnify your client for any inaccuracy of a rep and warranty. No problem there. But it's Clause B. Any non-meritorious claim by a third party against my client, the seller, that if meritorious would give rise to an inaccuracy of the reps and warranties, it makes no sense to me.
Yeah, well, look, Sharon, this clause appears in all my buy-side deals, and it ties into third-party claims against the target company after the closing. That's the point at which, of course, the target company is going to be a wholly owned subsidiary of the buyer. So a suit against the target company is in effect a suit against the buyer. So let me give you a hypothetical scenario from the technology world that shows why we need the non-meritorious claims provision in Clause B up there. As you know, the acquisition agreement will contain a flat rep on the part of the sellers that before the closing, the target company has not infringed the intellectual property of any third party.
Well, I just have to stop you there. I think it's going to have a knowledge qualifier, but keep going. That's fine.
It won't. I mean, I promise you. On the East Coast, they let you knowledge qualify the reps and warranties. Not here on the West Coast, where they know a thing or two about technology. But let's, we're going to get a flat non-infringement rep. And let's assume that a month after the closing, some third-party plaintiff out there brings a lawsuit against the target company, alleging that the target company, in fact, infringed the plaintiff's patents and other IP before the closing. Now, the acquisition agreement is going to provide, at least for IP claims like this one, that my client, the buyer, will control the defense of that lawsuit. And if you've ever been involved in an IP infringement claim, it's going to cost millions and millions of dollars of legal fees to defend that lawsuit, the lawsuit brought against my subsidiary, the target company. And suppose that after a lengthy trial and a brilliantly spirited defense by my client, the court finds that the third-party plaintiff's infringement claim is non-meritorious, that there was no IP infringement. Let me just turn it over to you. Who do you think should bear and pay the millions of dollars of legal fees that were run up in successfully defending that lawsuit?
Oh, I think that's really simple, Rick. I think it should be your client. Your client should bear the risk because my client gave perfect reps. There was no inaccuracy. So no indemnity. It's really pretty simple. End of story.
See, I admit that the rep was accurate in that scenario, but my client sees the risk allocation a little differently. And I think others who represent buyers very often in the audience see it the same way. Those fees were incurred because of allegedly infringing activity that occurred before the closing on the seller's watch. Even though that activity was ultimately found to be infringing or not to be infringing, why should the buyer bear the extensive liability for those legal fees? The rule should not be whether or not the rep was accurate. The rule should be our watch, your watch. And that should be the standard for fixing liability here. And the allegedly infringing activity occurred when your clients owned the target company. They occurred on the seller's watch. And besides, your rule would create perverse incentives. It would be ironic that a client like my client, who does a superb job in defending the infringement lawsuit, gets punished by having to bear and pay these millions of dollars of defense fees. Whereas if the buyer did a lousy job and the court had found that there was infringement, the buyer would get rewarded by getting indemnified against the infringement liability and against the defense fees. It makes no sense, and I'm not even going to get into what happens if there is a settlement where there is no admission or denial of liability. But let's step out of character, Sharon, because I know that in real life you represent a lot of serial acquirers of private companies. What's your experience with the non-meritorious claims indemnification provision, the Clause B provision up there? Do buyers typically ask for it in the current market? Do they get it?
Well, let's first look at what the Deal Point study shows. The Deal Point study shows only 10% of the time do buyers get this. In my experience with big serial acquirers, we get this with some frequency. Not all the time, not a majority of the time, but definitely a lot more than 10%.
Well, look, out of character, I'm frankly surprised that buyers with negotiating leverage don't always ask for these non-meritorious claims provisions. They can be very, very important, and I think the rationale for requesting them is very logical and sensible. So that's our practice pointer on non-meritorious claims provisions. Always ask for them on the buy side, and hopefully you'll get them. So let's keep going. Anything else you don't like in my draft indemnification provision? How do you like my draft of damages definition?
Well, let me just start with this. I think the consequential damages is just something we're not going to agree to. That really needs to be excluded. I mean, you remember about consequential damages from law school, right?
Vaguely.
Well,
look, I don't think excluding consequential damages is appropriate, Sharon. Courts allow recoveries of consequential damages all the time. So why should my client give up a right that it already has under established law, the right to recover consequential damages? Why should the buyer agree to artificially restrict the damages it's otherwise entitled to recover?
Because companies do it all the time. And in fact, I was taking a look at the license agreement between our clients, and in fact, in that license agreement, there's a disclaimer of consequential damages. So the parties have already agreed that this is totally reasonable. You see it in those kinds of agreements, you see it in consulting agreements and other services agreements. It's pretty typical to carve it out.
Yeah, Sharon, look, I don't disagree with you as to some types of agreements. I'll concede that in the context of, say, consulting agreements, it may make sense for the recipient of the consulting services to waive its right to recover consequential damages. That's because there's an inherent mismatch there. That's because the potential damages to which the consultant would be exposed if he or she were liable for consequential damages would be astronomically high, catastrophically high when compared to the puny dollar amount of the consulting fees he or she is going to get paid. But that rationale does not apply in the M&A context, where the buyer is paying and the sellers are receiving a full price for the target company's business and for the related representations and warranties being made by the sellers. So in the M&A context, a consequential damages waiver is not appropriate, while it might be in other contexts.
All right, Rick, I think you deserve a win here, so I'm going to give you that one.
Yeah, and Sharon, look, at the risk of piling on, let me give you and the audience another couple of reasons not to agree to a consequential damages waiver in an M&A deal. First, sometimes consequential damages are the only meaningful damages that you can recover associated with the breach of the seller's representations and warranties. Take the case of the seller's rep that it has all governmental, that the target company has all governmental permits needed to carry on the business. And suppose that after the closing, the target company's business gets shut down for 6 months because it lacks a key operating permit. A permit that only costs a few $1,000s to obtain if the company is in compliance with the permit conditions, which it probably isn't. With a consequential damages waiver in place, all the buyer would be entitled to recover, and I'm sure you'd be happy to pay it, is the $3,000 permit fee, but not the millions of dollars of lost profits associated with the shutdown of the business. You'd be giving up the right to recover those lost profits with a consequential damages waiver. And more on that from Rita later on, I think. And then finally, representing the buyer, I'm always reluctant to give up a category of damages that I don't fully understand. And take a look at the quote on the slide from the wise Delaware judge Leo Strine, who's out here somewhere. We always have to cite him at least twice in every M&A presentation. But he observed in a 2011 decision that the laundry list of excluded damages, such as consequential damages, might have been put in the merger agreement by lawyers who themselves didn't know what they were doing, were unclear on what those terms actually mean. The fact is that the case law is very squishy and very confused, very inconsistent, one might even say incoherent, on what constitutes consequential damages and what doesn't. If my client waives the right to recover consequential damages, I'm not really too sure exactly what we're waiving. And despite my law school education, I concede that I don't fully understand consequential damages. And as Judge Strine observed, I think a lot of people, maybe even including some judges, may share my lack of comprehension. So for all of these reasons, I think a well-advised buyer normally doesn't and shouldn't agree to exclude consequential damages from the definition of indemnifiable damages, and that's our key practice pointer here. And Sharon, I know you and Saeed have some statistics on the slide on market practice here.
All right, so Saeed, tell us, what is market on consequential damages?
Over time, the number of deals that include consequential damages waivers have decreased substantially, and I think you see in the vast majority of deals, as the ABA study shows, that parties are silent. essentially, exactly as Rick was sort of going through, you as a buyer want to preserve your ability to argue for the damages. So you'll note that the expressly included is hardly ever there, because that would be strange to suggest you automatically receive these categories of damages that people don't understand. But it's clear to argue that you should have the right to claim you're entitled to the damages if the court agrees with you. So we vast majority of deals we see, the parties are silent on consequential damages.
All right, well, if I had prevailed on Rick and excluded consequential damages, would I be fully in the clear on also excluding lost profits?
Interestingly, no. Going to this same point as to these categories are not clear and distinct what is what. There was a case, the ABC case, American Bottling Company case, essentially where they had a consequential damages waiver, which says that consequential damages, including lost profits, were not recoverable, and the court found that the lost profits in question were actually direct damages. They were not consequentials. So again, I don't know how or why a type of lost profit is direct versus consequential, but I think it just goes back to the same point. The cases are all over the map, and you want to be able to make your arguments in court.
All right, let's look at another type of damages that maybe doesn't get its full due in negotiations, attorney's fees. Rita?
So this may not be as funny and entertaining as Sharon and Rick's negotiation, but I think it's something that everyone will be very interested in, and that's how to recover attorney's fees when you're litigating, when you're a primary party to a dispute in a merger agreement. So first we'll start with the first case, which is Schneider v. Kuntz, which is the validity of an attorney fee shifting provision. And just to give you a little bit of background, under Delaware law, Delaware generally follows does follow what's referred to as the American rule. That means that each party pays its own attorney fees. And the court has historically said that the court should not interpret provisions in an expansive way that would be inconsistent with the policy considerations behind that American rule, and that indemnification provisions are presumed not to require reimbursement for attorney's fees as a result of substantive litigation between the two parties to a purchase agreement, unless there's clear, unequivocal language and articulation of that intent. So now, what does that mean, clear and unequivocal articulation of that intent? We've had a few cases through the years addressing that. I have to tell you, I'm not so in prepping for this panel, still not so clear what clear and unequivocal language is, but Rick did have language in the slides, if you go back and look online, that gives you a good example of what that would look like. So the first case is Winchell v. Viacom International. The indemnification provision there looked a lot like probably what you're used to seeing in a purchase agreement. You have indemnification for breach of reps, and then you have a definition of losses. And the definition of losses includes reasonable attorney's fees and expenses. And that was it. The court found that that was not unambiguous language, that it needed to be more specific, and was unpersuaded that that one clause in the definition of losses was sufficient in order to shift attorney fees to the other party. Similarly, the court was unpersuaded in another case in Ashland, but there, counsel went a little bit further, and they said that indemnification includes, losses include attorney's fees and expenses, whether or not involving a third-party claim. Well, it sounds like that means what's not a third-party claim, it's a first-party claim. That also was not clear and unequivocal. Importantly, in that decision, the merger agreement had a section on termination fees and recovery of the break fee, and there the court noted there was a clear and unequivocal fee shifting provision in that part of the contract, and therefore raised ambiguity because the provision in the indemnity section was not clear. So lastly, we get to the current case, which is Schneider v. Kuntz, and there the definition, the indemnity related to earnouts, the provision said seller may be indemnified and buyer shall indemnify and hold harmless sellers for failure, breach of the covenants to pay earnouts, to pay deferred consideration, to pay other types of claims that could only be made by the seller. And so there, the court, even though the definition of losses didn't reference first-party claims, didn't have any magic language there, the court could conceive of no circumstance in which there could be a third-party claim in breaching those covenants, which were expressly carved out in the included in the indemnity provision. So, in conclusion, you need to be very, very clear, including spelling out entirely not just whether or not those attorney fees that are covered relate to a third-party claim or otherwise, but that it relates to first-party claims for indemnification under this agreement. The second attorney fees dispute that we have, or indemnification, relates to whether or not contingency fees in a litigation are considered reasonable attorney's fees entitled to reimbursement under a provision. So in Williams, the dispute was not over, as we had just discussed in these other cases, was not over whether or not the fee shifting had appropriately been unequivocally shifted to the other party. It was in this dispute over whether or not a reverse breakup fee was payable. And in that case, there was a prior litigation where the Williams Companies was awarded $410 million in a judgment as liquidated damages. Then the Williams had to sue for payment of the attorney's fees. At that point, Williams switched with its counsel from an hourly fee to a contingent fee. And ultimately, that was 15% of the $410 million judgment, or $74 million. Also, as the prevailing party, the merger agreement provided that Williams was entitled to prejudgment interest. And so, but it didn't say how that interest was calculated. So with respect to the first part, the court found that, and went through assessment of whether or not the contingency fee was reasonable, and said that yes, the contingency fee was reasonable and that should be reimbursed. Interestingly, the court noted that if the parties that were sophisticated parties represented by well-known counsel wanted to shift that, they could have specifically excluded contingency fees, but they didn't. And then because the merger agreement was silent on interest, the court found that it would calculate interest, compound interest. So what do you do there? If you're on the sell side, and if you're on the buy side, you definitely want to consider whether or not it makes sense to specifically include contingency fees, specifically exclude them. And it's interesting, some people have sort of been playing with this formulation. One that I've seen is contingency fees will be recalculated as reasonable to be the hourly rate. I've actually never seen that in agreement. I'm sure there are some, but it is something that you should be aware of.
All right, so the lesson there, I think, is nothing is boilerplate. Attorney's fees, there's a lot to think about and allocate there when you're negotiating a transaction. All right, so next is, in the last few minutes, we're going to do our lightning round. We're going to test the brevity of our panelists and their ability to cover a tip or a case in 2 minutes or less, actually, given where we are. So David, I'm going to turn it over to you. What can you tell us about ice cream company mergers?
Ice cream company mergers with socially conscious former owners need to be looked at very carefully. In 2000, this was sold to Unilever. The case went up when the Unilever, because of stuff that was happening in Israel and the West Bank, where it had a franchisee that was on basically selling to both sides, which Ben & Jerry's, the founders themselves, disagreed with. They felt that Unilever could unilaterally sell the business and avoid the issue. The problem here is that there was a provision in the agreement that gave a board of directors some very specific limited rights, and that was for perpetuity. It's probably a mistake to do something like that. I think in most of the cases where you would see these types of provisions for like employee benefits or other areas, you would specifically disclaim third-party beneficiary status. Here, the parties negotiated to retain that. Interestingly, the case settled with the transaction going forward. The settlement was not made public, but Ben & Jerry's didn't get the result they wanted.
All right, so Rick, why don't you tell us what we need to know about reasonable best efforts in 2 minutes or less?
In less than 2 minutes, I promise. Okay, those of you who do M&A deals know that acquisition agreements typically contain covenants on the part of one party or the other to try to do something, to try to accomplish something that is not entirely within that parties control. These are not absolute covenants. They tend to relate to things like obtaining regulatory approvals, satisfying closing conditions, but they fall short of requiring the relevant party to guarantee that a particular approval will be obtained or that a particular outcome will be achieved. And they use terms like reasonable efforts, commercially reasonable efforts, or even the ever-popular reasonable best efforts. And we call these types of covenants efforts provisions, of course. Now, if you're like most practitioners, you've obsessed over these various standards. You've spent way too much time, way too much of your valuable time in negotiating capital in arguing over what the right standard, what the right shade of gray here is. And in your mind, you've probably developed a hierarchy that best efforts is stronger than reasonable best efforts, which is stronger than plain reasonable efforts, which in turn is stronger than merely commercially reasonable efforts. But at least in Delaware, rest easy. Thanks to a series of recent decisions on the slide, stop obsessing, relax a little. These cases minimize the distinctions among the effort standard. They tend to suggest that they are all essentially the same. So rather than spending your time arguing over whether the relevant standard is reasonable best efforts or commercially reasonable efforts, the skilled drafter is much better off simply identifying specific examples of particular concrete tasks that one side or the other is required to undertake in order to satisfy their obligations. And even though we constantly remind you that the words matter in drafting M&A agreements, this may be one of those situations where the words don't matter quite as much.
All right, well, that's a relief. Okay, I feel like this comes up on every deal. Do you resolve a drafting ambiguity in your favor, or do you just let it go? Saeed?
As a junior associate, I would 100% have said, do not resolve it. Just take those little Easter eggs for yourself and use them as leverage against a counterparty later. Terrible idea. The courts have told me unambiguously that that does not work. In fact, these provisions, and Schneider, which we talked about in a different context, will tell you that if in fact the parties have an objective meeting of the minds, the little Easter egg you put in the contract with some ambiguous drafting is not going to help you, and whatever the party's intent was, that will be what your contract says. So if you want something, ask for it, litigate it up front. Don't hope for the best with your little nuggets.
All right. This next one kept me up at night. It's kind of a ghost story. Rita, what about wire transfer fraud?
Sure. In sorts in which involved a computer hackers intercepting an email communication of a law firm to successfully redirect over $3 million in merger consideration to themselves. They assumed the identity of the target stockholders, emailed the law firm, changed the bank and the wire instructions from an account in Utah to an account in Hong Kong. Under the merger agreement, the buyer was required to pay the paying agent the amount due to all stockholders. And although the buyer fulfilled these obligations, it just from the paying agent then got wired to Hong Kong. In a motion to dismiss, so it's important to understand this is not finally adjudicated, the court found that it was reasonably conceivable that the merger agreement required not only payment to the paying agent, but ensuring ultimate payment to the stockholders. Lessons learned: one, if somebody emails you and says, change my bank from Utah to Hong Kong, you better call them and make sure that's correct. Any last-minute changes to funds flow statements, changes to names, bank accounts, you need to reconfirm those, even if you confirmed it. And verbal confirmation is pretty much what you need to do these days.
All right. And apparently we all need to see the Maltese Falcon, because apparently the plot tracks this case, according to Vice Chancellor Glasscock. So I'm gonna check it out. Okay. In 30 seconds, my lightning round. Affiliates. Does the generic use of the word affiliates include future affiliates, or just the affiliates on the signing date? In Delaware, it includes future affiliates. In New York, it does not. So think about where you are, and do you want to clarify that or not? And I guess, Saeed, you'll tell us, clarify. Don't have ambiguities. All right, that wraps up our panel. Thanks, everyone, for your attention, and enjoy. You've got a break for 15 minutes. Thank you.